Loki. Yeah. Okay. So for those of you who don't know me, my name is Malika Iyer. I'm currently in the third year, and I participated in the judgment deliberation competition, which SPIL conducted as part of the International Law Summit. So that is why they called me here to talk to you guys about it. If we can, let's keep it informal as far as possible. And if you can, please turn your cameras on. I would appreciate that.
Hi Malika, thanks for joining in. So there are around 64 people right now, and most of these people I think have already registered for the JDC.
Oh, great.
And like we're going to keep this an interactive session, so you all can ask questions, you all can ask any doubts you all have. But please try keeping it general and not specific to the module, because we will not be discussing the module as such today. Malika will be briefing you all about how to research, what to do, what to keep in mind while talking, how to present your oral arguments, how it is different in the sense of a moot in terms of preparation and presenting your arguments. And I'll be talking about the basic rules, what to keep in mind when you are like according to the rules such as scoring criteria and the dates, the important dates, the way you present yourself, the structure of the competition, all these basic rules of the competition, which are also mentioned in the rule book. So I think we can begin now. Okay, so firstly, the competition is on the 16th and 17th of October, which is a Saturday and a Sunday. We will have 3 rounds in the competition, the prelims, followed by the semis, and then the finals. So each room which you will be assigned to will have 3 judges in them. There'll be judges as in the participants. There are 2 kinds of judges in this. One are the marking judges, who will be actually marking you all and scoring you all, and there'll be another set of judges which will be the team, which will be the participants. So you will refer to them as your brother judges or sister judges. This is not a counsel or client. This is more of a brother judge or sister judge. Second thing is that most of y'all have registered, so we have already informed y'all that the last date to back out is the 3rd of October. But for the others, please keep in mind that if you do register and due to some circumstances you cannot take part, please back out by the 3rd of October, because after that we will need to start assembling everything, and it will become very difficult and tedious for us to actually work on the competition. So please firstly don't try to back out. It's very easy. Don't get scared, but if you actually have to, then please try to keep it before 3rd October. Then the last day to seek any clarifications about the module is the 7th of October. And you all can send in your clarifications at our email address, spilmumbai@gmail.com, and we will definitely get back to you and solve any doubts that you have. The dress code is courtroom formals. Then some basic rules, please, once you're in the courtroom, your Navy will assign you a name and a number, or we'll assign you your number, basically, the judge, brother judge or sister judge, 3404, like however we decided. So please don't say your actual name during the entire competition. Your friends might know y'all, but the scoring judges do not. So it'll be better to maintain that. Then, okay, so now coming on to the rounds. So in this, it is a little different from a moot. Even though you will be presenting your arguments, one thing you need to keep in mind is that it is not you don't have the time to first present your arguments and then rebut the other person's arguments. In this case, it's a little different because you are presenting a judgment and you're not actually arguing for one side. You will be first presenting a judgment, followed by, so there'll be 3 judges in the courtroom, 3 brother judges, sister judges in the courtroom. So the first judge, which is Judge 1, suppose, Judge 1, 2, 3, Judge 1 will present his or her judgment. Then Judge 2 will present his or her judgment, followed by Judge 3 presenting his or her judgment. Now, this judgment that you present, you'll have 4 minutes to do it, and the entire 4 minutes is absolutely yours. The scoring judges, the marking judges cannot ask you any questions during these 4 minutes. No other brother judge or sister judge can interrupt you while you are talking. You can have your own speech prepared. You can have your own points to give out. You can time yourself before you come for the competition. Remember, you have 4 minutes entirely to yourselves to show the judges and to show the other people in the room what all you have researched about and what all you know. So each judge, 1, 2, 3, turn by turn, will present their judgments. Then comes the next round, which is the commenting round. Now, this round is 3 minutes long. And in this round, you will comment on your other two brother and sister judges' judgments. So suppose you stated, according to me, the judgment, not according to me, like whatever the framing is, like this country should not have done this. And then the other judge says, no, this country should have. And then they give their own reasonings that what they did is right. So I don't see any wrong in this. And they give their own reasonings. You can comment on that and state why you feel against it. Or you can also agree with that judge and say, okay, yes, that does make sense. And I agree with it. So maybe we can come to like this sort of an agreement, like half of hers, half of mine. Maybe this sounds like a correct judgment then. So you need to comment on the other brothers and sister judges' judgments. Now, in this 3 minutes, you again, your brother and sister judge cannot interrupt you or ask you questions, but the scoring judges can. They can, if you have stated something and if you have commented on another person's judgment, they can ask you, okay, but don't you feel this? They can ask you anything. Like it's not that this time is absolutely yours. They can randomly ask you questions. So you need to be prepared for that. And again, the line goes 1, 2, 3. So judge 1 will first comment, then judge 2, then judge 3. And you all will comment on each other's. Then finally comes the conclusion round. And this round is 1 minute. So now that you have heard all your brother, sister judges' judgments, you all have commented on them, they have reverted back to you, they have given you their opinions. Now you have 1 minute to finally summarize what you feel is right and wrong. You feel, okay, issue 1, this is my stance. Issue 2, this is my stance. Issue 3, this is my stance. This will be very brief. It's just 1 minute long. So you just state, okay, so finally I have decided this after hearing all my other brother judge and sister judges' judgments. And after deliberating on them, I feel that this. And that is what happens. Judge 1, 2, 3. Again, the scoring judges may or may not interrupt you during this 1 minute. It is at their discretion. And any extra time to be provided is again at their discretion. So please do not ask us. You can directly refer to the scoring judges for any extra time. Okay, now this was a little complicated. So if anybody has any questions, you can just ask me right now so we can clear it out.
Khushi, I had a question. I wanted to know that if we agree with one of our brother judges or sister judges, so does that mean that we are giving them an opportunity to score more points? Certainly because they have put a point across that which we feel is correct.
Okay, so in this way, so whatever judgment, so their judgment or whatever the issue they present forward, it wouldn't be that you have, it might be that you have never even thought of it this way. Or it might be that, okay, you thought about this, but you feel, you can say like, okay, my judgment can also be right, their judgment can also be right. So you should firstly appreciate your brothers and sisters' judgments for sure. You are like, I really appreciate the judgment you put forth, and I really agree with you on this point, but not on this point. So okay. So if you agree with somebody on a point which was different than yours, it might come across as good also that, okay, the judges can see that, okay, you have taken her points also into consideration, and you are also thinking about your points. You're not just like stuck to your own points. You're keeping an open mind, because that is what the comment round is actually about. And I think Malika can also answer this.
Okay, so it's not that if you agree with a different judge, you're giving points away to them. That is not true. The judges, the marking judges, do take into consideration that you have a good approach, that what you're concerned about ultimately is the fairness of the judgment. Just because you're agreeing with them, that does not take away from the fact that you had a similar thought. So don't worry, you're not giving points away.
Thanks for answering, Malika and Khushi.
Anyone else?
So any questions about the format of the competition should ideally be directed to Khushi. She's the right person to answer them.
Yeah, if I could just add that what since it is all about presenting your judgment and your opinion about the same, so is it necessary that we keep on researching about judgments that really favors our opinion? Is that so the format should be? I mean, just wanted to be clear about that what exactly this competition is based on.
Okay, so this Malika will be addressing right after I talk about the format. So this Malika will just get to it shortly. Like she's entirely going to talk about how to research, what to keep in mind about when you're researching. Okay, so Jui has asked a question. Can we get any demo session that actually okay. So she's asking for any demo session about how a judgment deliberation competition is actually conducted. So we have the message that you have received in which you found this link, and any message that we have sent forward, we've always included a drive link. So that drive link has the ILS in which Malika participated, that module, and the recording of the entire final session. So you can see exactly how the round begins and how you have the presentation round, then the commenting, then the conclusion, and how the judges can ask you any questions during the commenting and conclusion. It is clearly mentioned. So if I can also, okay, and you can also just mail SPIL. We can send you the drive link again if you cannot find it, or you can just message one of us. Okay, anyone else? Otherwise, then I'll move on to like just a few more points. Okay. So now after these 3 rounds, another thing to keep in mind is the scoring criteria. So the scoring criteria is expressly mentioned in the rule book, but just to show you all again where it is, and like just to give you all a brief about it here. If everybody can see my screen, this is the scoring criteria, and the participant judges will be marked on these 5 points. Their knowledge of law and the use of authorities, which is 15 marks, ability to make and reply to comments, which is basically in the commenting round, that is 25 marks, interpretation of facts and appreciation of principles of evidence, that is 25 marks, legal analysis and persuasiveness, 25 marks, and style, poise, and mannerisms is 10 marks. So even when you're preparing for the competition, remember to keep these 5 points in mind, because at the end of the day, it is a competition, and the judgment you present, that even though it is of utmost importance, there are also other things you're being marked on, such as style, poise, and mannerisms, and that does not come when you're searching for a judgment. That you need to keep in mind when you're presenting it. So remember to keep the scoring criteria in mind so that you don't miss out because of something which you didn't know. Like even though your judgment might be excellent and like on point, you might just lose out to somebody else because they were sitting straight, they were more close to the camera, they were using the correct terms such as brother judge, sister judge, they were not dressed correctly. Like it can be anything. So please, you have to wear courtroom formals, please remember that. So yeah, I think this is most of it. You can find this in the rule books as well. So just check the rule book, which is also in the drive link and in all the mails we've been sending you. Then finally, okay, the winners of this competition, that will be the winner judge, the runner-up judge, and the second runner-up judge. The benefit of this is that we will actually approach the winners and the runner-up. You will get the opportunity to be the team representing GLC in the International Law Summit, which will be held in the start of next year. So winning the competition also has its perks. You will get an e-certificate, and this judgment deliberation competition is actually one of a kind. So doing this is actually something which people find very interesting, and it's a great opportunity. So if you have any other questions about the format or any of the rules, you can ask me.
Am I audible?
Yes.
My question is not about the format. My question is about how to research. Since it's we are novice to it and we haven't tried it.
Okay, so Malika will just tell you immediately, like after this, Malika will just start about how to research and what to keep in mind while researching. She is the one who's in charge of this. So just wait for 2 minutes. If anybody asks any other question, otherwise Malika, you can start. Okay, I think Malika, you can start now.
Okay. All right. So thank you, Khushi. I think all of you have a fair understanding of what a JDC is and how it is different from a moot in terms of structure, correct? If you have not, you are now in the position of a judge. You are not a lawyer anymore. You are not arguing. You're not making arguments. Rather, you're looking at it from the other side. You're looking at it from a fair perspective. Two parties are here in front of you, and you want to make the decision that's best for both of them. Okay, so research, the pressing question everybody has. How do you research? Firstly, when you read the proposition, I suggest you take it, you sit with it and read it in entirety. There are going to be things you don't understand. There are going to be terms you don't understand, concepts, maybe procedures that you don't understand. So step one is underlining what you don't understand. Anything that you don't understand entirely, look it up. Google it. Simple Google search, Wikipedia. All right. The idea is just to get a fair understanding of what this means before you can start looking at it from a research perspective. So to give you an example, the last proposition, Khushi, have you shared that with them, the module for last year?
Last year's ILS module as well as the finals recording is on the drive.
Okay. All right. So that module, I'll tell you, there were certain terms that I didn't understand, like charter party or a demise charter or liquid naphtha or chemical tanker. Like some of these had no real bearing on the prop, like on the story itself. But then I just think it's better to always know what you're going into. Then there's going to be certain procedures you don't understand. So same, you do a quick Google search and you understand what it means, and then you move on to the next step. Then you talk about which court it is. This time it's the ICJ. Last time it was the Supreme Court. So because I can't speak about this year's prop, I will be speaking generally. If you have any questions, do ask. So whichever court it is, you would first look at the working structure of the court. Who are the judges? How many judges are there? How does it work? Am I audible?
Yeah, please continue.
Okay, I can't hear anything.
Malika? Hello?
Okay, yeah, I can hear you now. All right. So then you would look at the working structure of the court. Simple things like procedure. Every court has a set of rules it follows, correct? So you would read those rules. Then you would look at powers. So fundamentally, it is pointless to give a judgment that cannot be enforced, or pointless to give a judgment which the court does not have the power to give. So firstly, you will figure out what can the court do? What powers do you have as a judge? For this, you can refer to previous judgments. You can look at similar cases where things like this have been done. And you know for a fact that this can be done by the court. This you'll also find in the rules when you're reading them. So this is the purpose of reading the researching about the, that's my dog. Okay. So this is the purpose of researching about the court itself, to figure out what can you do, what can't you do, what limitations are there to your powers. So yeah, you can also look at previous judgments of that court, whichever court it is, to figure out how it works, what kind of, this will also give you a fair idea of what kind of language you're supposed to use, how the judges interact. These are various things you can learn from the judgments of that court. Then you come to the fact sheet. So your fact sheet is a very important part of your module. I mean, of the competition. There are 25 marks for interpretation of facts. So you look for events that occur. I like to make notes of my own, like underline things, highlight them, keep a separate paper wherein I list down chronologically what happened. And in all of this, it is equally important to look at what didn't happen. Like if there's something that's missing in the fact sheet, something that was supposed to be done by a party, but they did not do it, or a duty which they did not fulfill. So things like these, it's very important to take account of things that are missing in the fact sheet as well. Then you look at order, like the order in which things happen, the chronological order. It's very important to have this down. Once you have that, it doesn't confuse you further. Then this, okay, so you look for the parent case. Like every prop is based on a particular parent case. I don't know if I can tell you, this is like a life hack thing. Every prop, look for the parent case, be it a moot or a judgment. Look for it, will give you some idea. Sometimes there may not be like an exactly same parent case, but it will be very similar. So definitely look for that. and reality check it. Like this is what, can something happen in real life? A lot of times the propositions that you're given for moots or for competitions like these will be really far-fetched, and things like this don't happen in real life quite a lot. So then you look for cases wherein this has happened or something similar to this has happened. What can the court do then? What kind of arguments were made? What did those parties do, like in the facts of that case? What happened? So this gives you an idea into how real this is, or how much sense you are making. And then what happens if it's not realistic? Then look at existing law. What does the law say? How can you interpret the current facts to fit that law then? Or how can you interpret that law to fit your facts? So basically you need to work it around, and getting an idea of what happens in real life really helps you with this part. Coming to the next part about law. So how do you find out? You're in first year. It happens to everybody. When I first started doing this, when I first started researching for this competition, I had no idea what to do. So there are two basic ways to approach it. You can do it. You can either look at a party versus party approach, as in similar to a moot, like prepare arguments that if it's the Supreme Court, if it's, I mean, it's different, right? I did it in a Supreme Court way. So you can either look at what the petitioner would say, what the respondent would say, or you can look at it from a bird's eye view, as in what does the law currently say, and then look at what happened in your case and fit it accordingly. So there is no right or wrong way. It's entirely up to you. Both ways are good if you can manage. So as I said, either do a party by party analysis, or then you can look at it from a bird's eye view. So far, any questions? Am I going too fast? Am I making sense?
Yes, Valika, you're making sense. Yeah.
Great.
So I just had one question.
Go ahead.
And I wanted to know that, like, supposedly, if it is between two parties, does that mean we have to specifically, favor any one party that we are inclined towards, or does that mean we always have to give any neutral judgment, and we feel that this is, it has to be, and it is neutral?
Okay, so I'll come to that. That was my next section. But to answer in very short, you do not pick a party. As in, before you look at the law, you don't pick a party, because the law might be really different. So to answer your earlier question also, should you research on judgments that are based on your opinion? Ideally, you're not supposed to have an opinion before you look at the law, because your role as a judge is to ensure what is right is the judgment you're coming to, correct? So you would not prejudge the situation. You would do your basic research first, then come to an agree. Then weigh both sides, like figure out which issue. Like multiple issues will have multiple weights. Not every issue will be equal. Like one issue might be strong in favor of a party, the other might be better for the other party. So your judgment does not need to inherently favor one side. If issue one is in favor of the first party, it is not necessary that everything is in the favor of that party. It can be unequally distributed or equally distributed. So if that answers your question, I'll now talk about the sources of law. Like, how do you get to it? In international law, you can look at conventions, you can look at treaties, you can look at UN resolutions, like the General Assembly resolutions or the Security Council resolution. This again depends on your proposition. There's no one thing that fits all propositions. It depends on what you have. Yeah, so you can look at these. You can look at UN reports. A lot of these UN websites have a list of conventions, so that would be really helpful for you. Like for the particular type of law that you're looking at, it would be really helpful if you can go through those. And you can also look at not sure how helpful it would be, but you can also look at the UN Charter, or you can look at, again, reports published by these authorities. There are online libraries which contain all of these, and you can look at them. They're open access. And you can look at the ICJ statute. You can look at previous judgments or awards. So these are there on the ICJ website. You just need to know the date and the names of the parties, and you can pretty much find anything. And then you can look at books, you can look at commentaries, and you can look at reports, you can look at research papers. Now, one big question is, where do you find these? We do not have access to a lot of resources in our first year. Yeah, so how do you find these? There are websites where you can get this for free. One of them is called LibGen. I am not recommending that anybody illegally access books. I'm just telling you it exists. I'm not recommending it. I'm not saying you're supposed to use it. Just telling you it exists. So yeah, even if you don't have access to say iLaw or SCC or Manupatra or Cluvers or okay, you don't need it. You can access these open access journals, these sites. Okay. So any questions so far?
I have one question.
Go ahead.
You mentioned that it can be like the first issue is in favor of one party, the other issues can be in favor of other parties. Do we have to at the end pronounce that who wins this case or something? How will we decide that if who is winning if it is unequally distributed?
Okay, so even in real life, if you read a judgment, there is no concept of win or lose. Let me refer to like a situation that everybody understands. Constitutional law, basic. You all did the freshers moot, correct? So there are multiple issues. You can challenge the same thing on different grounds. Not all grounds are going to stand. So there's no such thing as or the win or lose. There are issues for deliberation, and then certain issues are decided in favor of one party. Other issues can be decided in favor of the other party. So this concept of a 100% win or a lose does not exist. Not to make it too ADR, but there is no such thing as win-lose.
Okay, thank you.
Okay. Yeah. So yeah, if that takes care of research, I'll come to the judgment bit now. This is not a mood. This is different from a mood. So you have to be more open to dissenting opinions. You have to be more appreciative that all the judges on the bench are not going to be of the same opinion. Different people are going to have different perspectives of their own, and you may not have thought about it from that perspective, the way Khushi said. So you have to be open to their opinions. You are allowed to ask for more information, as in, why did you come to this reasoning? Like when you come to your comment round, the presentation round, you're entirely supposed to talk about your judgment, about your view, or why do you think this is the right thing to do? Your reasoning bit needs to be very strong. Your reference to facts needs to be really strong. Don't quote me on this, but the law part is boring. Nobody wants to know about it. People do want to know. You're supposed to talk about it, but you have to place way more emphasis on why this should apply. Nothing is ever directly applicable. Like if I just say that in so and so judgment, so and so court held so and so, that's why we should do it too. But that doesn't happen. You still have to draw a parallel in the present to the present case. Like what is different, or what is similar, or why should you come to this agreement? Why should you come to this conclusion? So this is what you need to talk about. The judges need to see that you have given it a level of thought. You have considered the facts of the case right now, and you're not just saying that something needs to be done because somebody else did it in the past. Yeah, so again, you need to be more respectful. You need to be more formal, because consider it in a real life sense. Judges have to be in the same court for way longer. Like one matter can come and go, but they have to work with their other brother and sister judges for a long time. So they're not going to be openly critical. They'll be very critical of the judge themselves. You can criticize the reasoning, but you cannot say anything about the judge. So yeah, be polite, be cordial, be more formal, be very respectful, and this take note of the fact that this is a deliberation and not an argumentation. Like a moot is where you put forth arguments as to why you are correct and why the other side is wrong. So this is different, significantly different, in that you are deliberating on why you should do something, and you're trying to convince them that this is the reason why, this is the reasoning I have applied. I appreciate whatever you have done, but I think this is the better way to do it, but in a more polite way, of course. So as Khushi said, you need to be more appreciative of their judgments as well. So somebody may have thought about it from a different perspective, and if you don't understand it, that is okay. You are allowed to ask for more information, like, why did you come to this? I don't understand it for so and so reasons. Okay, I don't understand it for so and so reasons. Can you please elaborate more on this? And that's completely okay too. So they'll then in their response tell you about why they came to that conclusion and how it compares against yours. So yeah, for this to refer to how judges interact in this manner, you can look at judgments that have been you can look at judgments of division benches or larger benches, and in their arbiters, like the arbiter is where the judge gives his own opinion, and in those bits you can look at how the judge has differentiated between other cases, or how the judge disagrees with other judges on the bench. And this gives you an idea. You can specifically look at the language in which they do it. Like, you don't say you are wrong, I am right. You substantiate it by saying I don't agree with you. I don't agree with you for the following reasons. Like, you have to supply reasoning why your conclusion is a better fit than the other judge's conclusion. You have to be very respectful about it. You have to take into account that the judge does not agree with you. And when I say you have to be appreciative of their opinion, it also means whatever similarities you have in your judgments, I think you need to talk about it. So if I'm right, one of the feedbacks, like one of the things that my judges told me in the ILS was, when you talk about, when you are appreciating their judgment without talking about what you appreciate, it just comes out as a little condescending. Like, so if I just say that, I see Shreya Vasve here, if I just say ki, thank you for your judgment, like I really appreciate it, but, and then I go on to list down everything I hate about it, you know, dislike about it. So then that's a little fake, right? Like, why did I even say I appreciate it when I'm giving you a whole list of reasons why I don't like it? So then this sounds condescending. This is counterproductive. This might make you sound rude. So don't do that. Give reasons for why you appreciate something as well. So if there are similarities, or if you've changed your opinion after hearing to somebody's judgment, it's okay to change your opinion, to say that, okay, I thought about it from this perspective, but after hearing your presentation, I think I'm more inclined to accept your reasoning. That's okay. That's all right. Okay to do. Great. And you can then be more appreciative in the sense that, okay, I like that you refer to this perspective, and I understand it way more now. So you can cite certain cases that they refer to, certain other judgments that they did, and you can talk, okay, I like that you brought this into up. You can say that, okay, this is great research, I was not aware of this, or things like that. So basically that is that. And you can then also set a precedent. So you, as a judge now, the difference from a moot again becomes clear here. In moot, you would say so and so was done in this case, that is why you should do it, you should not differ from it. But here you this is a judgment deliberation competition, you are a judge, you have that ability to say, okay, courts thus far did this, but I don't agree with it. I want to do something different. I want to set a precedent. This should be done in the future, like if such a situation occurs. And I think this is the right way to go about it. You have to be very convincing. You have to have very, very strong reasons for doing it, because generally, courts don't set a new precedent unless there's an exceptional circumstance. If something different has happened, there is a valid reason for doing it. It's not up to their whim and fancy to say, okay, this is different, so I don't want to stick to whatever we've done so far. There has to be a marked difference from other cases, and that is why you have to be very, very strong in your reasoning to say why we should do something like this. Now here, it can get you in trouble. Like, this time it's the ICJ, so I'm not allowed to say anything about it. But if it's like a Supreme Court, like I told you last time, in the previous year we had the Supreme Court. So if there's like a bench strength specification, like as the division bench, you don't exactly have the same liberty to say I want to break free and set a new precedent. Okay, so if as a 2-judge bench, you don't have the same ability to say, okay, I want to break from this judgment as, say, like a 7-judge bench. So then you have to take notice of those facts also. If you want to set a precedent, you need to know when you have the liberty to set a precedent. So these are things that you need to look at. As I said earlier about the court, when you're doing that type of research, this kind of stuff would come into play as well. And yeah, then again, you have to have very strong reasoning for every conclusion. As I told you before, nothing is ever directly applicable. Like, you can't just state an authority and say this should be applicable, we should do this, without having good reason and good analysis of the facts that surround the case right now. So in moots, you can make an argument while knowing that, this is a stretch, this is not realistic, but you can still make that argument very passionately. But right now you can't do that. You have to have very strong reasons. You need to consider what both parties are facing. And as a job, as I told you, your job is to be, as a judge, your job is to be fair, to consider the situation of both sides and then make a decision. So your reasoning for coming to this decision has to be rock solid. You can't just say something because you feel like it, or you like one party more, or whatever. One party sounds cooler or anything. That is not a ground. You have to take into account the facts that have that are given to you, and you have to be very mindful of what each party would argue, and the law, of course. So your reasoning and your interpretation of law has to be top notch. Then, yeah, let's come to the deliberation bit of it. Do you want me to talk about oratory skills or anything? Yes.
Okay, Malika, if nobody else has a question, I had a question.
Go
So,
ahead.
like, if you're presenting a judgment and then you come to the commenting round or the conclusion round, so if you're commenting on the other judges' judgments, so do you address them issue by issue? Do you address them? Okay, since there are only 3 minutes in this round, should I address every issue issue by issue, or look at it as a whole? So, okay, so I see overall that you have mentioned this.
Okay, so overall, there is not going to be like a strong concept of overall, because every issue is going to be different, right? The reasoning for every issue, the facts surrounding every issue are going to be different. So if you have less time, just pick up your most important things, the glaring dissimilarities and the reason why you strongly disagree with a particular point. Bring that up first. So like eliminate all your important ones and leave your less important ones for last. So just generally for everything, like in a moot also, judges are going to grill you, they're going to ask you questions. So make your most important points first and then leave the less important ones for later. If you have time, you can address them there. Does that answer your question? Okay, so I'll also speak about oratory skills, because all of us, when we come to law school, we feel like, okay, if I can't be like a great orator, then I don't have a future. But that's not true. Really, in all of these competitions, how good of an orator you are doesn't matter as much as you think it does. To some extent, yes, but there's always room for improvement. All of us can always get better. So don't think of yourself as a lost cause. That is something I did, because when I was in first year, I used to be really disappointed by my oratory skills. I used to be really anxious to speak. So I'll just tell you about something that helped me overcome it, and like some things I've learned now. Like it's going to be an online competition. It's different. There are certain advantages you have which you wouldn't have otherwise had. So firstly, put your Zoom view on speaker view. Do not put it on gallery view, because if there are 8-10 different faces in the room, you're going to keep thinking about, oh, you be mindful of the fact that there are people watching you. Put it on speaker view. Only look at who is speaking. Block everybody else out of your vision. Don't try to look at them. That helps you feel more at ease, because there's only one person you're talking to, and it feels more like a conversation. Puts you at ease. Do that. Then make points. Like I don't like having a speech prepared, because I'll tell you what that does to me. If I break from the speech, like if somebody asks me a question or if there's an interruption in the speech, then I get really focused on how like it's different, that I can't start back from the same point. So then I prefer not to make an entire speech. I prefer to make points and an order in which I want to address them. So the way you can do that is, for now, you can just type it down on a Word doc, and you can minimize your Zoom, like keep the view over here so it doesn't look like you're reading and things like that. Or there's another way. You can just simply write them down and post-it notes. You can put them on your laptop screen, so it doesn't even look like you're reading. You don't have to like look down into your paper or anything. Judges generally tend to appreciate eye contact. Like in real life, they would really like it if you would look at them. But right now, since we don't have that, try to look at the camera as much as you can. Try not to look around. Try not to look around as much as you can. Then definitely practice before you go. Like making your points is great, but definitely do a couple oral practices before you go. Best not to show up directly. If you're confident enough, good for you. I am not, so I prefer to do a few practices before any competition. Then speak slow. This is a problem that I've always had in my freshers note. If I can tell you, the judge actually told me that I rattled on for 6 minutes. I rambled on, and they could not make sense of a single word I had said because I was speaking so fast. So in competitions, you definitely don't want that to happen. You want to speak very slow. You want to take pauses between your sentences. Like even when you begin a new point, a new issue, you want to take a pause. So let it sink into the head of the judge. Like a lot of times it might happen that you make a point, you move on, and halfway through your next point, the judge realizes, oh, this is what she was trying to say earlier. So this ideally should not happen. As you are speaking, the judge should understand what you're saying. So for this, break your sentences down. Don't keep really long, complex sentences. Use simpler language, simpler sentences. Break them down to smaller bits and emphasize as you speak. Yeah, that's, and take a pause, like every now and then pause. Don't just use your entire 4 minutes to speak. If you get a question, like this applies to modes as well. If you get a question, there's no need to give a background. You can just stick to the answer of the question that they've asked you. You don't need to explain or do anything. You just give a very short answer. Chalta hai. And if you don't immediately know something, no problem. It's completely normal. You don't have to know an answer right away. You can take a few minutes to think, and then you can, not a few minutes, but a few seconds to think and then answer the question. Or if you don't know, it is okay to say, okay, I'll answer it later, or I'll come to it in the course of my arguments. Things like that are completely fine. Ideally, take a few minutes, take a few seconds, think, and then answer. There is one trick that I like to do. It's the classic water trick. I keep a glass of water with me all the time. If you ask me a question I don't know, I'll say, okay, I'll just pick up my glass, take a sip, wait, and then speak. That gives me some time to think, right? So this is a good life hack that you should do, online or offline. In offline competition, they actually give you a bottle of water to take with you everywhere. And I strongly suspect the entire purpose of doing it is to give you a few seconds to think before a question. So definitely do that. If you stutter, if you break from your speech at any point, if there's an interruption, it's entirely fine. It's completely okay. You don't need to beat yourself up about it. Just take a few seconds, form your thoughts, get them back in order, start again. Happens. If you watch my final rounds, it has happened a lot of times, and it happens everywhere. So don't worry about it. It does not have any bearing on your score. The judges are considerate enough to take this into consideration. They care more about your content anyway. So if your research is good, if your reasoning is good, if your content is good, they don't care about things like this. As for screen sharing, you are allowed to screen share things. Khushi, is that right? They're allowed to screen share, right?
Mentioned in the rules as well that if you have a judgment you want to show the judge, so in a normal, if it was a physical moot or physical JDC, you would be handing over the your judgment through the court, through the CC, and then they would pass it on to the judge. But in this case, you can just share your screen. We just let the CC know before you start the round that I want to share a judgment, so just allow screen sharing. Like that's all. Just do it beforehand so that later there's no lag or any problems.
So by now, I assume everybody knows what a CC is. They've probably been CCs themselves. But if not, I'll just tell you, there'll be a person in your room who's called the court coordinator. They keep time. They keep updating on the, on Zoom, they keep sending messages on the chat. In real life, they used to have a bell. In GLC, they used to just press the bell and hold up a placard to show people, okay, there are 5 minutes left, there are 2 minutes left, please stop now. So in real life, if you wanted to share something, you would get printouts of those, highlight them, put a flag on the page, then hand it out. Like while you're speaking, just hold it out. CC will come, take it from you, and give it to the judge. You don't walk up to the judge and give it to them. You hold it out, wait for the CC to take it, and then they take it to the judge. So right now, you can screen share on Zoom. You can screen share. In my experience, screen sharing is a little distracting. So try not to switch your screen too many times. Say you're sharing your screen and you want to refer to multiple things. Don't keep switching tabs constantly, and make sure you have things highlighted. If you want to share, say, a report or a part of a report, make sure it's highlighted. Make sure you're on that page. So if you keep switching tabs, scrolling a lot, so this distracts the judge. And whenever a judge is distracted, remember, they're not listening to what you're saying. They're looking at your screen. They're just trying to figure out what is where. So only screen share if you really have something you need to show, like, without showing. I mean, this is my take on it. You're free to have a different opinion. I personally prefer not to screen share.
Okay, I just want to add something. So in one of the rounds I went to, a judge actually said it in the end feedback session that right now online screen sharing is very beneficial, because when you actually present a judgment in person to a judge, the judge will look through it, look at any random point, and just ask you a question from anywhere, and you need to know the entire judgment that you've given. But when you're screen sharing, you are only showing what you want them to see. That one paragraph on that one page is what you're showing them. So they are only looking at that. They're not going to be looking through the judgment and ask you random questions about what the judge might have said or the judge might not have said. So in that sense, it can also be very beneficial to screen share. But as Malika said, as long as you know what you want to show and where it is, and you don't keep switching tabs and distract yourself and the judge. Because sometimes when you're even looking through tabs to find what you wanted to show, it might become distracted and you will also lose your flow of thought. So just keep that in mind when you're doing it.
Yes. So Khushi did give you an important life hack when it comes to screen sharing. Only show the part you want to show the judge. But that being said, you should always read the entire judgment. You should know the facts of the judgments, especially the ones you're citing. They can ask you at any point, and it's really embarrassing if you have to say, I don't know what happened in that case. Like, your marking judges may ask you, or if it's or if the other judge, the sister brother judges have done good research, they'll be able to differentiate, like say that the facts were different in that case. They should not be applied. The facts are significantly different, so much so that the same principle should not be applied here. So if they're good, even in modes, like for every competition that you go to, you should read the entire judgment, know the context. Not every principle is applicable everywhere. We learned this the hard way, so you should learn this because I'm telling it to you. Choose to believe me or learn it yourself. So, okay, that is it. Then, yeah, in your presentation round, I would say focus it a lot more on facts. Definitely, you should be talking about law, but as I told you earlier, your reasoning and your interpretation of the facts should be there. Whenever a prop is given to you, as I mean, I already told you earlier, but there'll be certain things that are not happening. So it's great for you to highlight those as well, that this should have been done. Had this been the case, I would have come to a different judgment. But in the current circumstances, it is significantly different. You can also, as I said earlier, like case judgments are distinguishable, right? So you can always say that in a particular judgment, so and so was held, but in here in the current facts, this was specifically not done. Or in the place of, I can't really give you examples without context right now. I can't deal with your module, so forgive me on how general this is. If you have doubts, do ask. So basically you can say so and so was not done, or so and so is missing from anywhere in the prop. Rather, the contrary is true. So that is why we should break from that judgment. So things like this definitely need to be there. Analysis not only of the facts here, but facts of other judgments that you are referring to should be there. Then, yeah, your reasoning should be very strong. You don't have the liberty to make very far-fetched conclusions that you know are blatantly stretched thin. So don't do that. Be very mindful of the fact that you have to be fair to both parties. You need to come to a probable, a likely judgment which a judge looking at these circumstances would do. So be mindful of that fact. And as long as you have that down, if you have some concept of reality check, and you have good reasoning for coming to your judgments, I think you're pretty much good to go throughout the entire competition. So yeah, that's all I had to say to you guys. If you have any other questions.
Yeah, I had one doubt. So the judgments I guess we will be citing. So how many judgments should we preferably refer for during our research time?
I'm sorry, but your voice was cutting in and out. So
Yeah,
are you
I'm so
asking me
sorry.
how many judgments you need to cite?
Yeah, preferably, so not cite, but while researching for the competition, preferably how many judgments should we refer to? Should we go through?
As many as you want. There is no hard and fast rule. I would definitely say that you should not rely on just a few. You should look at a lot more. Like if you're saying that something has been consistently held by this court, you do need to look more into the history of how similar facts, similar circumstances were dealt with by that court. Like you should not go by just one or just two judgments.
Okay. And in case of citing, we just have to cite those cases with which we defer our judgment, or
not defer. If you're relying on something, say this.
Okay.
I mean, I just gave you an example. Like you can defer depending on the facts that are given to you in your module, and yeah. So basically, you can do that, but you would also be citing judgments that you're relying on, right? So and so court held in so and so case that so and so should be done when XYZ circumstances exist. So you have to cite those as well.
Okay.
You have to cite those. Not as well. You have to cite those.
Okay, got it. Thank
Okay.
you.
Also, like when you're citing the judgment, the judge if it's a famous case and so we'll be calling international law judges. So they know the judgment. It is very probable that they know it. So don't try to just be like, okay, the judge might just not know there are thousands of judgments. He might not know this. So you will just say anything. Okay, this had happened, that happened, and this was the conclusion. Like, you cannot do that.
Yeah,
They know the judgments. That is why they have asked you the question. Otherwise, they would not have bothered to ask.
if a judge knows you're faffing your way through it, then they'll mark you low. So don't do that. Go well prepared.
If you're citing anything, know it from top to bottom, or it's fine, don't. Like, that will be better than the judge asking you a question and then you not being able to answer it.
So Siddhi has just asked, the judgment we are referring to should be a recent one, not necessarily. I mean, if it's really, really old, say like from the 1800s or something, then preferably it's better to have recent authorities to back it up that this was done in this century. So that really helps. Unless it's a really, really old one, it's not necessary that you need to have very recent ones, because sometimes they may not exist. Like something may not have happened after a particular year. There's nothing you can do about it. It's only happening now. So no requirement of recent judgments.
Oh, I have a question, Malika. Have you mentioned, like, what about so landmark cases, and what is the power of, like, if this precedence, like, can we state that, okay, this is a precedent, so I'm following it, and I'm a 1-judge bench and it was a 3-judge bench, so I have to follow it. So this is my verdict.
You can, but that, as I said earlier, like if that is your sole reason, you'll be using out points for analysis of facts. So again, like nothing is ever binding, and you should not be saying it that I'm only doing it because I'm bound to do it. You should be giving a bit more of your analysis, or if you want to, yeah, you should be giving a bit more of your analysis. That should not be the only reason why you're giving a judgment.
Okay.
Hello, I have a question, Malika, I wanted you to address. So basically, suppose that if I am going first in the commenting round and then my other 2 participating judges, poses question or contradict my judgment. So in the commenting round, should I, address those questions, or should I just stick to concluding my judgment given that it is just a 1-minute round?
Yeah, so good question. You can address them in the conclusion round because you've not had a chance to respond to those questions. So then your 1-minute conclusion round would be the time when you address it. Generally, I mean, I don't generally the judges give you
yeah, so another thing I can add here is that if you feel that the other 2 judges have very highly contradicted your judgment and you really want to state some points forward, like before you start concluding, then in that case you can also ask the scoring judges, because this is completely at the discretion of judges. It is not SPIL's discretion. You can always ask the judges, if I may just have 1 minute to comment on what my other brother and sister judges have stated before I start my conclusion round. The judge will, if the judge can see that, okay, you have to clarify some things to them because they have highly contradicted it, then the judge will give you time. Nothing will happen in 1 or 2 minutes. Like, they will say, yes, please proceed. And then you just very briefly summarize it, so you don't take a lot of time also, because then you can even move on to conclusion round. So like,
I would also suggest that don't introduce new material in the last round, because it's unfair. Other people don't have a chance to comment on it, to address it. So don't keep all material that you're introducing to your 4-minute presentation round.
So does that clear it, Sushmita?
Yeah, it clears it perfectly. Thanks, guys.
Okay, does anybody else have any question? Okay,
Either I'm doing a really good job at explaining this stuff, or nobody has understood what I'm saying.
Sound like teachers now.
Technically, I am. I'm teaching them how to do JDC.
Okay, so if nobody else has any, okay, how do we address the marking judges? So just say,
so generally they won't be conversational with you. They'll only ask you questions. So you don't have to address them as, in moods, your lordship or whatever. You don't have to do that. You can just call them sir. or sir or ma'am or whatever, and that works really great. They'll just be coming in to ask you questions. They won't have a whole conversation with you where you have to like address them in a particular way. You can just call them sir or ma'am, or you can just answer their question.
But your other brother and sister judges, you need to refer to them as brother judge and sister judge. You cannot call them team A, team B, team C. No, you have to call them brother judge or sister judge, or brother judge A, brother judge B.
Yeah.
They are both brother judges. But always mention brother and sister judge, because they are also on the same panel as you, and you are not fighting with them. You are agreeing with them and you're trying to come to a conclusion.
It's very dramatic. It feels very nice. My brother judge, my sister judge.
Okay, yeah. So if anybody else has any question which they can't think of now, or like something which comes up when you start preparing for it, you start preparing for your arguments, you can always email us at spilmumbai@gmail.com. We will definitely get back to you. You can also approach any one of the SPIL members, anybody here. See, there's Shreya Saxena, there's Vidhi, there's Shushmita, there's Princy, Shaili, Shreya. And if like nobody, like if I missed out somebody who's already heard, like, and you're not on my first page basically. So like you can always just reach out to us. We will help you. And just like to confirm again, the dates are 16th and 17th of October. It's a weekend. So just make sure that you're free. And then suddenly something doesn't come up that day and you'll be asking us to change your slot timing or something, because it really becomes a very big hassle for us, because we have arranged judges and we have done everything according to some plan. And at the end moment, if we cannot approach judges and ask them to switch a time, or like even switch it with somebody else, because then it will be unfair for the other person, because we have already given them a time. Another thing, the last date to back out is 3rd. Please don't back out, but if you have to back out before the 3rd. And the last date to seek any clarifications with respect to the module is the 7th. So even if you plan to start sit and start researching about on this module on the 14th, try to give it a read once on the 6th, so that you can send in your clarifications before the 7th and you can get your doubts clear. Otherwise, it will become a problem for you later.
I don't recommend starting on 14th. Start early, do a good job, read as much as you can, know as much as you can, go there very well prepared. And if you do this, it's very easy. There's nothing like it. It's a fun competition. There's nothing else like it. When else will you get to experience this?
Exactly. This is actually a one-of-a-kind competition. I don't think anybody else in the country does this. So, like, this is a very different opportunity, and being a judge is a very different thing, and being a counsel is a very different thing. So this is actually a great experience, and this is just intra GLC. Like, there's no harm in giving it a try. You can always just participate to understand what this is and to know, like, to see it from a different perspective.
Yeah, in your first year, now in your second year.
Second, first, third, like this is open to everybody in GLC. There are a lot of 3rd years and 4th years and 5th years here. It is not only for freshers. It is open to the entire GLC. You get your friends to tell them about it, get your friends to come. How many days will be given to you. So we have already released the module, and the module is out. You can check it on the Drive link, or you can email us. You can ask as I've stated, ask any of the SPIL members, ask any of your friends. It's actually, you've tried to forward on every WhatsApp group. Check for the INTRA JDC module 2021. You should be able to find it. Otherwise, it will be in the Drive link. What will be the timing of the competition estimated? So the timing is not yet confirmed. So the slots are not yet confirmed. We will be looking at that once we have the total number of people. But it is on the Saturday and Sunday. Saturday will be the preliminary round, and Sunday will be the semis and the finals. So we might have morning, afternoon, evening slots. We might just have an afternoon evening slot. It will all be confirmed a week before the competition, perhaps. We cannot confirm anything right now.
Also, just to add on what Khushi already said, you can also access JDC module rules and also the registration link from going to our SPIL Instagram's bio. So there's a link tree in the bio wherein all the links are already specified. So you can directly access it from here. Otherwise, as Khushi said, you can obviously contact any of us and get it personally handed over.
Yes, I had forgotten to add that. And you can also check out our social media pages for any updates on the competition, because we will be releasing a lot of things related to the competition on the social media pages. So even if you miss out a message on WhatsApp, you will be able to find it on the social media handle. If anybody else does not have a question, then I think we can terminate this session. Okay, yes, thank you, Malika. It was a very, very insightful session. And we all definitely learned a lot, even though like some of us aren't participating in JDC. Like we know that, okay, this was even helpful from the perspective of moods actually. So this was very nice, and thank you for coming and doing this
Yeah.
for a fellow core.
Happy to help.
Okay, thank you everyone. So SPIL team, Malika, you all can stay back. The rest I think can leave.
Oh, everybody's so nice. Just actually saying thank you before leaving. Heartwarming.
Aryan Bhatia, NUJ